Welcome back to this module about the International Court of Justice. In the last video, we learned about the court's role in settling disputes between states. In this video, we're going to explore the advisory jurisdiction of the court. The ICJ plays a special role within the UN as an advice giver. Giving advice is not necessarily a judicial function, but the drafters of the UN Charter made a deliberate choice to grant the ICJ the capacity to give advisory opinions. Most of the court's work involves settling disputes between states, but occasionally the court also provides advice to UN bodies on legal questions. A number of these advisory opinions relate to highly controversial and political issues, such as declarations of independence, the Israeli security wall, and nuclear weapons. We're going to look first at when the court can play this unique advisory role, and then we'll delve into the court's 2010 advisory opinion on Kosovo. This is the court's most prominent advisory opinion in recent years. From time to time, the UN's political organs can benefit from authoritative advice on legal issues that arise during the course of their work. Both the General Assembly and the Security Council tend to encounter problems of international law. The drafters of the UN Charter anticipated that these political bodies would sometimes need authoritative legal advice. The Charter therefore allows the General Assembly and the Security Council to outsource their legal advice by asking the ICJ to give an advisory opinion on any legal question. The UN's specialized agencies, such as the World Health Organization and the International Labor Organization, can also request advisory opinions when authorized to do so by the General Assembly, and when the request falls within their mandate. It's particularly important that a request for an opinion falls within the mandate of the specialized agency making the request. This was demonstrated when the court decided that it could not answer a request by the World Health Organization because the request fell outside the mandate of the WHO. The WHO asked the court to give an opinion on whether the use of nuclear weapons by a state in an armed conflict would violate its obligations under international law, including the WHO Constitution. The court determined that the WHO could not ask this question because the mandate of the WHO allows it to deal with the health effects of nuclear weapons, but not the legality of their use. The authority to request an advisory opinion is limited to UN bodies. States themselves cannot ask the court to give advisory opinions. Only the General Assembly, the Security Council, and the UN's specialized agencies have this capacity. But states can participate in advisory proceedings before the court to the extent that they can present their arguments to the judges on the questions posed to the court. In addition, even though states can't directly request advisory opinions, they have been known to draft questions that are later adopted by the General Assembly and sent to the court. This happened, for example, in the case of the Kosovo advisory proceedings, which concerned a question originally drafted by Serbia. The ICJ's opinion on the Kosovo Declaration of Independence is a recent example of the court's advisory role. The Kosovo Assembly declared its independence from Serbia in February 2008, following nearly a decade of unsuccessful negotiations about Kosovo's status in relation to Serbia. Following an armed conflict in Kosovo in the late 1990s, Kosovo and Serbia were unable to reach an agreement on Kosovo's ultimate status, on whether the region would be integrated into Serbia or would become independent. The Kosovo Assembly's Declaration of Independence raised many thorny questions. Did Kosovo become an independent state by virtue of this declaration? Did the people of Kosovo have a right to secede from Serbia? And was the Declaration of Independence legal in the first place? So what was the question posed by the General Assembly to the court? In October 2008, the General Assembly requested an advisory opinion on this question. Is the unilateral Declaration of Independence by the Provisional Institutions of Self-Government of Kosovo in accordance with international law? This question is especially narrow because it focuses exclusively on whether or not the declaration was legal under international law. The General Assembly did not ask the court to provide advice on whether or not Kosovo had become a state or on whether the people of Kosovo had a right to secede. Despite its narrow scope, this request for an advisory opinion generated a great deal of interest among states because it related to the issue of independence movements, an issue faced by many states today. As a result, the court received a particularly large number of submissions from states in this advisory proceeding. In the end, the court gave a narrow answer to a narrow question. The court determined that there is no general prohibition on unilateral declarations of independence under international law. In making this determination, the court put to rest the question of whether or not unilateral declarations of independence are legal under international law. In doing so, the court did not resolve the issue of Kosovo's status, nor did it address the issue of secession more broadly. The court's contribution to the resolution of Kosovo's status was small, but international disputes are often resolved incrementally, one piece at a time. With the Kosovo advisory opinion, the court helped to clarify one aspect of a larger ongoing controversy. Technically speaking, the court's advisory opinions do not bind the UN bodies that request them. In the case of the Kosovo advisory opinion, the General Assembly was free to draw its own conclusions. In practice, however, these opinions are considered to be highly authoritative, and they contribute to a better understanding of international law with respect to issues like unilateral declarations of independence. In addition, the requesting body can decide to give such opinions a binding effect. The court's advisory opinions often attract considerable attention because they tend to involve highly controversial and political issues of concern to many states. The court has, for example, given opinions not only on the Kosovo Declaration of Independence, but also on the Israeli security wall and the legality of the use of nuclear weapons. But not all of its requests for opinions concern such topical issues. Many instead deal with more technical or obscure questions. In addition, the ICJ's advisory proceedings are greatly outnumbered by its contentious cases. In fact, since the ICJ came into existence in 1946, there have been only 26 requests for advisory opinions. The court's advisory function has always been secondary to its role in settling disputes between states. In the next video, we're therefore going to turn to the court's role in settling disputes between states. We'll look in particular at the court's role in settling disputes that concern the protection of the environment.